I'd like to welcome all Rotarians and guests in the room, and if there's any on Zoom, I don't think there are already. At this point anyways. My name is Steve Sperling, and I'm your co-president of this Rotary year. Each month, Rotary highlights a theme of interest for all Rotary clubs throughout the world. This month, the Rotary theme is peace building and conflict prevention. As you know, the president, Francesco Areza, highlights the theme of the year, Unite for Good. And let's see, we didn't have anybody sign up for the four-way test. So I'm just going to ask Lynn, could you
Absolutely.
stand up and help us lead the four-way test?
All the things they are doing. First is the through, second is the third, third. Third will build goodwill and better friendships. And fourth will be beneficial all concerned.
If you could remain standing and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic which stands one nation, under God, indivisible, with liberty and justice. Thank you. And we have Frank back to lead us in happy thoughts today. Is the basket back there? I think Aaron has the basket.
Oh, there it is.
So if anyone has any happy thoughts, that's great. Frank wanted an opportunity while you're waiting to think about it and talk about.
I went and got my license plates renewed, and I went ahead and got the new rotary plates. I'm just showing it off.
Oh.
They're available. But this has to be back on my car, otherwise I get a ticket.
So he's a trendsetter. We're all gonna want one now.
For Randy?
I don't have a dollar, but I got an announcement.
Okay.
You paid $20, because you got $1 going in on that, so anybody that wants to just comment on their $1.
I'll give Randy my $1 worth, so you go ahead and give your announcement.
All right.
Happy to announce that Ashok Patel has accepted the general chairmanship position of Rochester Pets this year. Again, he was it in 2024. And we've got a news release to the meeting tomorrow morning, so don't tell him.
Okay.
Don't tell them. Okay.
Other Rotarian.
With my dollar, that's now it's worthy. My mom agreed to getting back together with my dad in their apartment, which was a big step. We hope everything works out all right. It's good to get her out of short-term rehab back into the apartment, start her up. So that's my happy thought. Anyone else?
John, did we have? Seven.
Seven, so there's room for 5 more. We did one here. Anyone else? All right.
Okay, all right, thank you. And we're not absolutely sure on the total yet. We haven't had a, what do you call that? Well, right, we haven't had a board meeting and we haven't had a, reconciliation, I guess is the, so as we continue our goal towards $1,000. So today, maybe Randy, could I ask you to introduce, I think we just have, well, I guess it's just our speaker who is our guest today, right? So I'll introduce our speakers. And I want to congratulate everyone who has a birthday or an anniversary as listed on the pre-meeting slides that were here scrolling before you came in. So be sure and watch those. There are announcements there too. And I will once again send around the sign-up sheet for the next meeting on February 12th. And I forgot to do that last meeting, so recruiting at the last minute here. Sorry for that. Does anyone have any actual announcements that hasn't already spoken with me? Yeah. Okay, we'll go ahead to the announcements that we have here already. Rotary Awareness Day at the Capitol is coming up on February 23rd. And so the Rotarians will be meeting with the Congress members, and it's your chance to bend their ear if you want to, as a group. I want to make people, oh, go ahead.
I signed up for that, but nobody's reached out to me for anything, so.
Okay, you signed up for it through, okay,
Online, yeah.
probably because it's a little ways out, I'm guessing. But
February 23rd?
yeah, if you don't hear anything, maybe by next week, let me know. I'd like to make all our members aware that our club will be participating with the other two Rochester clubs in the district-wide 3-year initiative that's emphasizing water quality and conservation. You'll be hearing more about this as we get closer to April. The kickoff is on Earth Day, which I actually don't know the date, but I think it's mid-April. And I just want you to know about this because we have a news event that just happened yesterday. We're going to be partnering, our Rochester clubs are going to be partnering with the Isaac Walton League of the Rochester area for water quality. But one of the ways that you can get started right now, and Joseph and I both have, is to adopt a drain. We're going to be supporting this program, Adopt the Storm Drain, and wanted to just show you how easy it is. I watched a presentation on this, and we're going to actually try to get that city administrator Rachel Strauss to come and speak to our club if possible. If she's unable to, we want to get this done before Earth Day if possible. If scheduling doesn't work, I'll make a presentation quick because we do have the slide deck, but she's much more effective. She's a much better speaker. It is called Adopted.
I'm gonna make a comment. Our daughter is a director and responsible for the Adopt a Drain program at Hamlin.
Oh,
If I could get her to come down and be a speaker.
well, she was on our presentation. So is it Sophie or Sophia? Oh,
Kristen
Okay.
Bennett.
Oh, okay. She wasn't our speaker. This one was just a representative from Hamlin. I thought maybe she was the actual founder, but yeah, the two of them were our speakers. They did a really nice job, but that might be nice to have her come down and you get a visit out of her too then.
Yeah. What would the date be?
We don't have that set yet.
Okay, let me know.
If Rachel is unable to do one of the dates, they asked her yesterday, so she might respond soon. But if not, then that'd be great. We'll arrange a time. I think we've got 3 potential dates still before Earth Day. That everything's recovered. Well, you can adopt a drain in your neighborhood. Joseph, can you go to the next one to show them how easy it is? You just go to mnadoptadrain.org. Click on allow your, it asks you if you will allow them to use your location. And so it'll automatically bring up a map. This is my location. Bring up a map of the available drains right in your neighborhood. And there was one for me. And Joseph, I think, was there one? Oh, no, you didn't have one.
Well, what I found, my neighbor actually already took 2 closest drains, and so I chose third one in our street, and it's easy. So
Super easy, but best part of all is you get to name your drain. And so you should see some of the creative names that are out there for Rochester. What was yours, Joseph?
mine is cute Lulu because, little dog, and so.
The dogs are inspecting these drains all the time. Mine is the insane contained rain drain. So far, over 1 million pounds of pollutants have been prevented from entering our lakes and streams through this program. It's been around, I think, since 2017, maybe. It started in the Twin Cities, now it's in 18 states. So we want to support that, and it just coincides with the water quality initiative that Rotary in our district is supporting for the next 3 years. Okay, we want to highlight the Crutches for Africa. And I don't know if you saw this on your way in. This is the first announcement to our club, but somebody already got the word out because we had walkers dropped off today. The event will be on, I believe it's April 11th at 125 Live. That's where the collection will be. And so we need some volunteers to show up to represent our club at that collection and help out. I think we just only need 3 now. And the sign up is done already. So we have enough time. I don't think there'll be any issue getting the signups, but it's available in Club Runner, right, Lori?
I'll have it in lots of bar.
In Luxembourg, okay, that's even better. And we want to highlight too that February is also Share the Love Month for Rotary International Foundation. This is a good time to remember all the good things that our donations do throughout the world. Stuart normally is here. He wanted to be here today, but he's still going through some cancer treatments for his dog up in Minneapolis or in St. Paul campus. So he asked that was happened to be on a Thursday during this time. He's going to get back to coming to meetings as soon as possible, but he has a survey to go over, and it's nice. He's pretty well versed in where our grants are going for this calendar year. I don't know those off the top of my head, otherwise I'd be happy to share them with you. And a reminder that for our 3rd Thursday of the month, this month, we're having Representative Kayla Betzold, representing Rochester, coming to present on the possible natural gas franchise fee that the city is considering. That's probably the first time we've heard about this, but there's a possibility of a franchise fee. They're trying to seek feedback on that franchise fee, and it's your opportunity to give that feedback. Oh, I forgot to mention about the Share the Love event. There are incentives for contributions to the Rotary International Foundation right now. They do these periodically throughout the year. You can get bonus points towards Paul Harris Fellows by contributing during February. Okay. Before we hear from our speaker, I would like to mention that registration for our fundraiser, major fundraiser, the Rochester Rotary Ramble, in partnership with Med City Meander, is now officially open. Remember the date. The save the date is on now on May 23rd, which is Memorial Weekend. It's Saturday of that weekend. So there is a page there for volunteer sign up already posted, and so you can sign up for our part of the. You can also volunteer for the Med City Meander if that's easier, closer down. Our part will go a little bit out in the country, and our rest stop tentatively is planned for being in the city of Elgin. And we haven't decided yet if we're going to, well, we may solicit a sponsor from Elgin. So that's why we're unsure. There's a really nice little park that's right on the trail that would work too, but it's also always nice to get some actual personal sponsorship. So we are continuing to work out the details, as I was mentioning here, but this option significantly reduces our risk and our cost for putting this on. And it's going to be important that people pitch in, hopefully, both leading up to the ride. We'll need organization, we'll need fundraising, that kind of thing, but the Med City Meander group is taking care of all the registrations, they're taking care of the signups, they're taking care of permitting, they've taken care of the route planning. So it's a big help. But some things that we still will need, I don't know if you're familiar with what SAG drivers are or SAG vehicles are, but they're the vehicles that go on the route to make sure the riders are safe. if riders have a difficulty, if they have a flat, if they have, you don't have to know how to change a flat, but if they have, was tired, if it's raining or something like that, and they just want to be done, the vehicles will pick them up and bring them back to the start. The rest stop volunteers are needed, and we'll also need people to help mark the route the day before. So those are just examples of some of the volunteer things that we will need to provide. So we hope to have your support in this effort to make it a success and hopefully for years to come. This time I'd like to introduce our speaker, Judge Marcia Krieger. Marcia has served as a federal judge for 32 years. From 1984 to 2002, Judge Krieger served on the U.S. Bankruptcy Court for the District of Colorado, and it was its chief judge between 2000 and 2002. Judge Krieger was also a member of the 10th Circuit Bankruptcy Appellate Panel and taught both at the University of Colorado Law School and Stern College of Law at the University of Denver. She was appointed by President George W. Bush to serve on the United States District Court. She served as chief judge of the court from 2013 to 2019, and then took active senior status. She then moved to Minnesota and has handled matters in the District of Minnesota on special assignment. She is now on inactive status. Judge Krieger has been honored by numerous professional and civic organizations during her career and looks forward to being of continued service to citizens in Minnesota by explaining how courts work. Please welcome Judge Krieger.
Thank you all for having me here today. And it's a special privilege for me because there's something in that lovely introduction that I didn't include in the information that I supplied to Steve. And that is that 50 years ago today, I was studying at the University of Munich, Maximilian Planck Institute. I was in law school there as an international Rotary Fellow. And it is my pleasure, having gone through that experience, which I'll tell you just a bit about, to be able to say thank you to Rotarians today and Rotarians in the past, because that is a wonderful program. And I am very blessed to have been a participant in it. One of the things that's most interesting to me is I've just learned that my Rotary advisor in Munich, Dr. Ernst Steindorf, who was a law professor there, also was a renowned expert and the first person to write about European law. He fought in World War II for the Germans on the Russian front and then in the Africa Corps, and was captured by the Allies and transferred as a POW to a POW camp in Colorado located near Trinidad. That POW camp was largely populated by officers in the German army. What's interesting about that is that that's where he learned to speak English. He already spoke German, obviously, and he had grown up near the Ruhr, so he spoke French as well. And when the war was over and he went back to school, he had a professor that said to him, I want you to come with me to Paris because you speak French and you speak English and you speak German, and I want you to be my aide. Adenauer was there at that meeting, and it was the first meeting that ever was conducted to try to bring businesses together in Germany and France and the Benelux countries. These were at that time coal and steel operations. And that was the genesis of the European Economic Community and ultimately the EU. Now, I found that really interesting, particularly now, because I had majored in college in international relations and studied in particular the effect of multinational corporations on political integration among different countries. And I didn't realize all of the expertise that he had. So I didn't take advantage of that at my young age of 22, and I wished I had. But I am ever so grateful for the time he spent with me, teaching me about German law, teaching me about German culture, and being a worthy advisor during the time that I was there. I must tell you that the last time that I spoke to a Rotary Club was 50 years ago in German. Today, I'm here to talk with you a little bit about the state and federal courts and how they work. Hardly a news cycle goes by these days that you don't hear about some court decision. And whether it's on the internet or it's commentary or it's on TV or it's in the newspaper, it's reduced generally to a sentence or two to tell you what's going on. I feel very strongly that my ethical obligation under the Judicial Code of Conduct requires me to make our system as transparent as possible. And although the Code of Judicial Conduct prohibits me from making political comments, and there may be some questions I can't answer for that reason, I am very concerned that our population does not know enough about civics and how government works. We know that from the statistics that indicate that civic education in the public schools has been less than adequate for more than 40 years. And as a result, there are many people who think that, for instance, the two houses in Congress are the Democrats and the Republicans, not the Senate and House of Representatives. So I want to turn just to a refresher here as we talk about courts. And I'll ask Joseph if you would turn to our next slide. Here are two common myths. The first one is, I'm going to take my case to the Supreme Court. Ever heard that? And the other one is, don't make a federal case out. Both of those imply that somehow we control whether cases get into the federal system and that only important cases get into the federal system. So I'd like to talk a little bit about what goes on in the federal system as compared to what goes on in the state system. Next slide. State courts can hear a wide variety of cases, and but federal courts can hear only certain types of cases. When we talk about the jurisdiction of courts, let me ask you, what kinds of things do you see in state court? Anybody? Traffic tickets, divorces, probate litigation, real property disputes, things like that. That's a broad base of jurisdiction. Many, many things are resolved in state court. But in federal court, we have limited jurisdiction. And our jurisdiction is limited to those issues that arise under federal law or disputes between states or between parties from different states. And sometimes on appeal, a challenge to a state court ruling. So going back to that idea of I'm going to take my case to the Supreme Court, we don't have any control over whether the Supreme Court hears a case we're involved in. They get to choose whether they are going to consider that issue. And we call the request that we make for them to hear that a petition for a writ of certiorari. And that is our request that the United States Supreme Court hear this issue. Well, if it arises under state law and a state court has made a determination, it must go all the way through the appeal process of the state system before a request can be made of the United States Supreme Court. So needless to say, as I go over some statistics with you, you will see that very few cases get to the United States Supreme Court. They take very few cases and they determine very few cases. When we go on to the next slide. Now, this is a diagram of the federal court system and the state court system. Minnesota is our state court system. And even though I am not a judge from Minnesota and therefore cannot comment on Minnesota law because I've never had to apply it, I can tell you a little bit about the differences between our system and the federal court system. What you see here are some measures of cases, the numbers of cases that each system handles. So if we start at the bottom level, the United States District Courts, that's the trial court in the federal system. I'm a United States District Judge. I'm a trial judge. There are 94 districts in the United States, and historically, they have handled roughly 270 to 275,000 cases per year. That's across 94 districts. Recently, as of May 2025, there were 26,000 cases filed in the federal courts just this year in May. And I can tell you the way we count them in the federal system isn't on a calendar year basis, so the statistics are just a little bit off. But the number of cases that are usually pending in the United States District Courts, when we measure them for 2024 through 2025, it would be 290 cases. Let's compare that to the state courts. 89 million cases are filed in state courts. So we have many more cases, much broader jurisdiction in the state courts. If we go up the line a little bit, we go to the appeal level. United States Courts of Appeal, there are 13 United States Courts of Appeal, and historically they usually ran about 52 to 55,000 cases. Recently, there have been fewer, 40,000 or so among those courts. And if we go to the state courts, they're intermediate appellate courts, and that counts the Court of Appeals and also the Supreme Court. Roughly 295,000 cases are in state appellate courts. If we go to the Supreme Court, the highest court in some cases, it's in the state courts, there are 50 of those, handle about 85,000 cases. That means they've come through the intermediate level and then they've gone on to the Supreme Court in the state. And that compares to 96 cases in the United States Supreme Court. Now, I can tell you from the federal statistics that more cases are pending before the United States Supreme Court this year than prior years. But in the 2024-2025 time period, there were 56 signed opinions. 42% of those were unanimous. And 20 decisions were made on the emergency docket. You've heard about the emergency docket. People talk about it as the shadow. But what it really is the determination of what's going to happen during an appeal. And these are emergency motions that the Supreme Court hears. And many of the rulings that you hear about in the news are rulings with regard to temporary restraining orders and temporary injunctions, which are the hold it in place, don't do anything else until we get this resolved kind of determinations that are made by trial courts and affirmed by the circuit level courts. And then a request goes to the Supreme Court to decide whether there should be an injunction or not. Often you hear in the news or read in the news that someone had won that, won the case on this or won the case on that, when that isn't the case at all. All that has been determined is whether an injunction will stay in place while the case is pending. And because the legal process is complicated enough that many of broadcasters and journalists don't understand it, they don't understand this is just an intermediate decision. As I say in my chambers, I always said, is the ice cream melting? Do we have to do something right now to keep it from melting? So that would be my first observation with regard to what you're seeing in the news right now. Always think to yourself, is this a final determination, or is this just an interim determination? And as you note, the Supreme Court almost half the time renders a unanimous decision. And what's interesting about that is when we hear on the news, you would think that all decisions are partisan split decisions. But that really is not the case. Almost half are unanimous. Let's go to the next slide. Now, federal appeals, you heard me say, go to courts of appeal. There are 13 federal appeal courts, and you can see on the map that most of them are regional. The region that we are in is the 8th Circuit. Colorado was in the 10th Circuit. But I have to say to you that it originated in the 8th Circuit in the 1800s. So I feel a little bit more comfortable saying that I'm familiar with the 8th Circuit historically because Colorado was part of that circuit at one time. Now, in addition, there are some specialty locations, and those include islands that we have jurisdiction over and specialty courts like the patent court. That is an independent court of appeals that handles only patent cases. Next slide.
Oh, can I just ask clarification? Is so Circuit 9, does that also cover Hawaii, Guam?
And Alaska. It is the largest circuit in the country. And it covers the most territory. It has the largest number of cases on a circuit level, the largest number of judges. It is sometimes referred to as the very liberal circuit. Sometimes the 5th Circuit is referred to as the very conservative circuit. But all of the circuits have attributes that are the same in that their judges sit in panels of 3. And if a party is unhappy with the decision from the panel, the party can ask for the whole court of appeals to reconsider the decision.
It's interesting, it doesn't seem it's by population, like ninth has gotta be huge compared to fifth.
Yeah,
Or why isn't it by population percent?
well,
What's the initial reason that started way back when?
Congress created, first of all, the districts, and there are 94 of them across the United States. And Congress also created the circuits. Now, part of that was a political decision as to who was going to be what circuit and who was going to be what district. But the other perspective is that we have not changed the designation for many, many years. There have been efforts to divide the Ninth Circuit into two different circuits, which would make a lot of sense, but Congress has never been inclined to do that.
What year,
I'm sorry?
what year was it started?
Well, it was started in 1776, actually, I should say 1789, when the Constitution was adopted.
Your Honor, I was just going to point out that historically, the Fifth Circuit was divided, I think it's in the last 30 or 40 years into the 11th and 5th. They
That's right.
set that up. I think that's the last time anybody changed it.
I think that was about 50 years ago, I think.
Okay, I seem to remember it in my lifetime.
I do too. And that was the most recent change. But it takes Congress being willing and desiring to divide the circuits to act. Otherwise, we stay with this picture. Does that answer your question?
Thank you.
Okay. Next slide. Anybody been in the United States District Court for the District of Minnesota? I know you have because you've appeared there. This district court sits in a number of different locations. The two primary locations are the courthouse in Minneapolis and the courthouse in St. Paul. Those judges also rotate to sit in Fergus Falls and also in Duluth. So they go on the road to handle cases that are up north and out west. Colorado was the same way. We sat in Denver, but I often went to Durango and to Grand Junction to try cases. Here, there are 7 active judgeships, same as in Colorado. Population's about the same as in Colorado. And 8 senior judgeships, all fully staffed right now. There are 8 full-time magistrate judges and 1 part-time magistrate judge. And then the bankruptcy court, as a unit of the federal court, has 5 bankruptcy judges. Now, I want to make a distinction here because it's something you don't hear about on the news as well. There are 2 provisions of the United States Constitution under which judges are appointed. One is Article 1 and one is Article 3. I have been an Article 1 judge and I am an Article 3 judge. An Article 1 judge does not have the jurisdiction nor the authority that an Article 3 judge has. An Article 1 judge is a magistrate judge or a bankruptcy judge or an immigration judge. They are appointed not through Congress, not with a presidential nomination, but for a period of years to serve in a quasi-administrative capacity. And Article 1 judges do not have the same latitude to enforce their orders as do Article 3 judges. So you very rarely see any exercise of contempt authority in an Article 1 court. That's why you don't see contempt authority with immigration judges or magistrate judges or bankruptcy judges. Article 3 judges, on the other hand, are not appointed for a term of years. We're appointed for life. And I always say lifetime tenure, lifetime target. Because it goes on until you either pass away or resign your commission. To be an Article 3 judge, you have to be nominated by a president. It was George W. Bush who nominated me on September 10th, 2001. And if that sounds like a date sort of familiar to you, it is because September 11th followed right afterwards. And it's interesting, I was part of a group of judges who were nominated on the 10th, and it was customary the next day to have a personal call from the president who nominated you. So I'm driving down to work. I'm the chief judge of the bankruptcy court at this time, and I'm driving down to work thinking this is going to be a great day. I might hear from President Bush. And on the news, I hear about the Twin Towers, and all of a sudden, my focus is not on whether I'm going to get a congratulatory call, which we never did, but it is on should I close the courthouse in order to make sure that people remain safe. So my point there is that presidents are the ones who nominate members of the bench under Article 3. We're appointed for life, and we are confirmed by the Senate. I was confirmed 99-0. And that was common at that time, a long time ago. That judges were not, it wasn't a partisan kind of confirmation process. If you were qualified, you were confirmed. Okay, let's go to our next slide. Here are our Minnesota courts. And we have 10 districts, and I'm going to ask our attorney here in the audience to be sure to correct me if I misspeak.
Oh, there are 10 districts and we're in the third.
That's correct. We're in the third. And the number of state court judges currently is 321. So compare that number, 321 trial court judges, to the number of federal trial judges for the District of Minnesota, 7. Fewer judges, fewer cases. Okay, let's go on. The Minnesota Court of Appeals is the intermediate level of the appellate courts in between the trial court and the Supreme Court. And if someone is unhappy with the outcome of an appeal to the Court of Appeals, they then can request consideration by the Minnesota Supreme Court. Next slide. Now, here are notable differences between judges and courts in the state and federal systems. Minnesota judges are recruited and evaluated by our Judicial Selection Commission. They're selected and appointed by the governor. And regardless of how they're initially appointed, they have to run for re-election within 2 years of their initial appointment and every 6 years thereafter. Now, I know in Colorado, the system was similar. And one of the reasons that several judges and I put together a public education program called Our Courts in Colorado was because we had stood in voter lines and heard the people in back of us say, I just vote against all the judges. I don't pay any attention to who they are. I just don't like judges, so I vote against them. And what we realized is that citizens really didn't know that they had the right to vote for or against retention of a judge, and they didn't know what to think about when they're looking at what a judge has done. They're just glad they were never in that court. And so they figure that they don't need to worry about that. I don't know if that's the case in Minnesota, but in case it is, I encourage you to encourage your friends and neighbors to think about the judges that they're voting for, whether or not they are fair and impartial, whether they're timely in their rulings, whether or not they have been reversed for failing to apply the law correctly or abusing their discretion. Those are the kinds of things that you want to know. Now, judges can also be directly elected in some certain circumstances, and they also will stand for re-election as necessary. Federal judges, as I have explained already, come in two flavors, Article 1 and Article 3, and those are two different terms and processes by which the judges are selected and the terms that they serve. Next. Now, both systems seek equal justice under the law. And there are several components to this. If we were here for a longer period of time, I would divide you into three groups, and one group would be the prosecutor, and one group would be the defense, and one group would be the jury. And I would ask each group what it is you want out of the legal system. And invariably, I know from doing many presentations, the ones that are the prosecutors say we want to win. The ones that are the defense attorneys say we want to win. But the jury says, I want a fair and impartial process. And that's where I'm going to go to next. In order to have a fair and impartial process, we must apply the rule of law. And then the next slide is a fly-in, I think. We have to follow established procedures. Whoops, go back. There we go. And we have to have fair and impartial judges and juries. Anybody here serve on a jury? Okay, you remember the jury selection process, being asked questions? It's a little different in state court than it is in federal court, but the purpose of this, as I used to tell the attorneys before me, is I know that my job is to ensure that there is a fair and impartial jury. I know that what you want is a partial jury. And so in the federal court, I, like many federal judges, conducted the entire voir dire myself so that prospective jurors were not examined by the attorneys directly. I would take the attorneys' questions and make them less pointed, generally speaking, and see if we could get a jury that wasn't being sort of selected based on whether that juror would be likely to favor the defense or the plaintiff or prosecution. Now, let's go to the next slide. Some people think when they hear stuff on the news and they hear that a decision has been made, they say, I wouldn't have decided that way. And if you were to ask me a question about whether I would have decided the way another judge did, I would have to say, I can't tell you. And that's for two reasons. First, ethically, I can't comment upon pending cases, nor can I comment about the outcomes in cases. Why is that? Because the system works on the basis of what happens in each individual case. And I will not undermine the credibility or the correctness of another judge's determinations. But there's another practical reason. I'm just like you. I don't have the evidence. I haven't heard the witnesses. I haven't reviewed the briefs. I don't know what arguments are being made. And therefore, I cannot speculate as to what the correct outcome is. As a society, we focus a lot on outcome. Prosecutors would like to win, and actually they have a duty to make sure that the process is fair and impartial as well. Defense attorneys want to win, but they also have a duty to make sure that the process is fair and impartial as well. People who look from the outside want, or parties to the litigation, want a particular outcome. When you go to see an attorney, you want to know if this particular controversy is something you might take to court and win. You don't want to spend your money going to court if you're not going to win. It's outcome focused. But judges are not outcome focused. We are trained to do something different. We don't look and define justice as the outcome in a case. We look at the process by which the determination is made. And if you can see the slide, maybe I can back up a little bit so everybody can see it. It's a little bit like an equation. The determination is built upon facts as established by admissible evidence. So if I don't know what the evidence was, I couldn't comment on the outcome. Plus, you have to consider the applicable law, statute, rule, or binding case law. And you have to follow the correct procedure. So we have the federal rules of criminal procedure, we have the federal rules of civil procedure. And part of what the judge's job is to make sure that those rules are followed. I used to tell my law clerks that if they would think about it like this, start with the facts, look at the law, look at the proper procedure, and you come up with a decision. But if that decision strikes you as biased or unfair or odd, go back and check your work. Look at whether you just considered admissible evidence, look to consider what particular law applies, be sure that the proper procedure is used. And if you do that, and I agree with you, then that will be the outcome. Why? Because I can live with an outcome that is procedurally just. I'm not looking at an outcome of who wins. I am looking at the proper procedure and what drives the outcome. That is a different process than most of us would use in our decision making. And I can't tell you that all judges use this formula the way I described it here, the way I used it. But they do essentially that same thing. And if you look at any written opinion, state or federal court, you're going to see at the top, one, why the court has jurisdiction. Is it in the right court? Two, you're going to see a statement of facts based on admissible evidence or stipulated facts. And you're going to see what law was applied to those facts. And at the end of that reasoning, you're going to see an outcome. And that is a reflection of this kind of thought process. So there's no question that when I go to court and I'm a litigant, I want a particular outcome. But when I'm sitting as the judge, it's like the jury, I want a fair and impartial process. Yes.
As a judge, you go through the proper processes and then your ruling is appealed. Do you have any saying whether it can be appealed or not? Or
No, it's an appeal as of right.
all the time and effort put into it and this made, but it goes away.
And there are 3 grounds on which a trial court's decision can be reversed. Okay? Tracks this particular formula. Did the court err in finding the facts? Did the court err in applying the law? Did the court err in using the right process? Now, that'll come out as, if you didn't use the right process, it'll come out as you exceeded your authority. You abused your discretion. If there's an error in law, what we would call that is chocolate versus vanilla. I interpret the law this way, you're on the higher court, you interpret it another way, you get the final say. And as to facts, almost always the appellate court defers to the factual findings by a jury or factual findings by a judge. Why? Because they don't really have the evidence in front of them. And so what weight you give to evidence as it is presented is reflected in the decision. So there are 3 grounds that constitute reversible error. And that is a clear error of law. I chose the wrong law. There is a failure to interpret the law the way the Court of Appeals sees it. That's chocolate versus vanilla. And there is abuse of authority or discretion. And that is, I didn't follow the rules. I didn't make sure the process was fair. Yeah.
Could you speculate or tell us the ethical dilemmas with AI in the courtroom or in preparing the narratives?
I would love to, except that I took senior status before AI became a thing. And there's a reason why I'm not handling cases right now. And one of those reasons is I would have to learn that.
In our medical practice, it's getting difficult to write a prior authorization and a letter based on our AI tools to facilitate getting the insurance coverage, while the insurance and the pharmas are playing using AI to say why we shouldn't be giving.
Right, and it's like 2 AIs talking to each other. And the real problem that I see with AI, this is not me talking as a judge, this is just me speaking personally, is you don't know what AI considered. With this process, you do, because there's a record. And part of my job in following the rules is to make sure that record is as clear and precise as possible, so that if I've erred, the appellate court can correct it. But with AI, you don't know what they consider. Yes.
This is a little to the side, but goes along with a couple of things that you've been talking about. You asked if any of us had been on a jury. I was selected to be on a jury. I was selected for that jury, but then it was settled out of court. When things are settled out of court, what involvement does the judge have? And if you accept a settlement out of court, is that then immune from being appealed because you've accepted that outcome?
Okay.
I know that's a bunch of stuff, but it's just.
No, those are really good questions. Let's start with criminal cases. 99% of criminal cases will be resolved with a plea bargain. Not a trial, a plea bargain. And that is an agreement between the prosecutor and the defendant as to what it is that the defendant should be held responsible for. It's based on a lot of different things, the strength of the prosecution's case, how much time and effort and money is going to be spent on the trial, the likelihood of a particular sentencing range being applied with a particular conviction, all kinds of things like that. As to that, a judge has absolute 100% discretion as to whether he or she accepts the plea agreement. Okay? If I don't accept the plea agreement, we either go back and talk again or we go to trial. In a civil case, the parties reach an agreement and the role of the court isn't as involved. Why? Because the parties are negotiating based upon money or interest or costs or whatever. And most, well, I won't say most, a lot of civil settlements, parties want to keep confidential. Now, I'll comment on that in just a minute. With regard to those agreements, if it is a class action suit and a few other limited situations, the court has to approve or not approve the settlement. But for the garden variety two-party dispute, the court doesn't have to approve it or not. Essentially, the settlement becomes a new contract between the parties. And it bars appeal because they have resolved all of the issues between them, and this is an agreement. Now, I want to talk about confidentiality a little bit. That's a philosophical issue. All judges have their own views on it. I can't speak for other judges, but what I can say is I rarely allowed a settlement agreement to remain confidential. And the reason I didn't is because the public has a right to know what happens in its courts. And if you use the public court system to resolve your dispute, the public has a right to know how you resolved it. If you want to go to arbitration, you can keep it secret. But I did not philosophically believe that private settlements in civil cases should be kept secret. Other questions?
I have one more.
Okay.
The presidential pardon.
What about it?
Keep it.
Do you need one?
Keep it apolitical and bipartisan, but what's the process to appeal or contest?
I'm going to direct you to look on the internet under the name Liz Oyer, O-Y-E-R. And the reason I'm going to point you that way is she was for many years a pardon attorney in the Justice Department. And her description of the way it worked is much more complete and thorough than what I can give. She would say, however, that that is not the process that is being used today.
Was just going to make a follow-up comment. I have the pleasure of taking care of patients who were attorneys that were tasked with corruption settlements for United Nations agencies.
Can you speak up just a little bit?
One of my patients was an attorney for the United Nations, and their role was an independent investigator of potential corruption by heads of different agencies. And it seems like you do need an independent authority that is fair and impartial to contest and challenge some of these very powerful and influential forces.
That is the idea behind independent counsel appointments in the federal system, where there's some appearance that a Justice Department, say, for example, is answerable to the president. An independent counsel can be appointed to do the investigation. Now, having said that, I give great deference to the prosecutors who take an oath to prosecute without fear and favor and to investigate as fairly and impartially as they can. So if they can do that, then they're the ones to do it.
Sounds like you'll be a lifelong target.
Sadly so. Sadly so. Yes, sir.
Let's have two questions. One based on the first. If the system functions on the consent of the public, I guess, we all agree that we will function under this system. What about the current situations where the federal courts are saying this and the people involved are paying no attention to what's said?
That's why I started out with the observation that Article 1 judges, immigration judges, don't have extensive powers of contempt.
So
Article 3 judges do. And I have held cabinet members to be subject to an order to show cause why they should not be held in contempt, requiring them to appear before me and explain to me why they're not complying with orders. Now, that's what you're starting to see, is the exercise of that contempt power. And sometimes you have to go above just the attorneys before you because they can't control their client, and you have to go to the client itself.
do you have faith in the system that ultimately this will come out fairly?
I believe in the system. I wouldn't have devoted 32 years to it if I didn't believe in it. But it requires the public to know how it is supposed to work and to demand that it work as it is. Does that answer your question? As best I can.
Would like to thank Judge Krieger for her wonderful presentation. And then thanks for your presentation today. We will be making a donation to the Legacy Project in your name.
Thank you.
Thanks to all our participants in the meeting today, as well as our volunteers. John Woodruff, Sergeant at Arms, Big Frank did the meal facilitation and double duty with Happy Bucks. And then the introductions. And Joseph as well for AV and tech support. I'd like to remind all Rotarians to go forth in the world and unite for good.
Can I make a positive thought contribution?
Oh, sure.
It's just National Prayer Breakfast Day, and may we all pause to pray for our local, state, and national. So I give you some money.